Good evening and welcome to the First Amendment and AP Government with Mr. Kuhn. All right, promise will be short and sweet. It's only 4 slides, and we'll try and get to the heart of some of the First Amendment cases. These are all in your book, some more recent ones too that may not be in your textbook, but just want to give you a little explanation of each of these so it becomes a little easier when the time comes to study them. All right. Um, we have several clauses of the First Amendment that we're familiar with. All right, Mr. Gorski's coming in to bother me. All right, yes, that's Mr. Gorski. Okay, so ignore that. All right, so in the First Amendment we have two clauses dealing with religion. Just the door. All right, sorry about that. Okay, so one of the clauses says Congress shall make no law respecting an establishment of religion. We call this the Establishment Clause, which prevents a national religion from being established. And Congress shall make no law. So again, the First Amendment is protecting us from a national government doing this. As we know through selective incorporation, more and more of the states are now required to follow this amendment as well. So even though it says Congress, it has now been read to mean any state government entity. All right, in case you're reading about this evening, Engel versus Vitale, and again, it's school sanctioned prayer is unconstitutional because it violates the Establishment Clause. And through the 14th Amendment, which says your life, liberty, or property cannot be taken away without due process. Somebody being forced to pray by a school administrator or given the opportunity to pray is having your liberty taken away at the expense of the state, and therefore it violates the 14th Amendment. But we'll discuss that more tomorrow. All right. Another case that's very likely to appear on the test, all right, is Lemon versus Kurtzman. This is more known for just the Lemon test. All right. 5 points to anyone not named Junior tomorrow that writes Lemon test on our word wall. All right, preferably in green because it's a yellow sheet of paper for that. All right, so we want to make sure we know the Lemon test. All right, which basically says that any law that deals with state money going toward anything religious in a private school, all right, has to pass the Lemon test. All right, three provisions, all right, for the law to pass a test. So if Carmel, for example, is going to implement get federal money for a program, that money has to pass this test, all right? The most important thing to know is that the money has to have a secular purpose. Secular meaning non-religious, all right? So the purpose cannot deal with religious if its primary purpose is that. So for example, in the old days, I don't know if we still do this or not, but Mundelein used to have a driver ed teacher go over and teach driver ed at Carmel, all right? So our state tax dollars that was being paid to Mundelein is going to teach driver ed to Carmel students because Carmel can't afford to teach driver ed, okay? And unless that teacher is Carrie Underwood, that program passes the Lemon test because driving is secular. All right, there's no religious reason behind that. All right, hopefully you got the Carrie Underwood reference. All right, number two, the principal effect cannot aid or inhibit religion. It cannot make religion more. It can't make it easier, beneficial, nor can it get in the way of religion if you're giving money to a private school. And then the third thing is it cannot create an excessive entanglement. All right, between government and religion. So it can't get unnecessarily involved between the two. All right, if the law does all three of those things, it is said to have passed the Lemon test. All right, now Wallace versus Jaffrey, this will hopefully come up in discussion tomorrow. This overturned a law in Alabama that set aside voluntary prayer or voluntary time in the school day for prayer. So they would start the school day again with a moment of silence so you could pray if you want to, okay? And that was found unconstitutional because it was, again, endorsing a religion by saying you could pray. Now, why do we do this at Mundelein High School? Because when that law was passed, the law said that the moment of silence is for silent meditation or prayer. So it is not exclusively for prayer, it is for silent meditation as well. And if you've been in my homeroom, there's not much of that going on. So you can guess how that works. Okay. Lee versus Weissman dealt with something called the International Baccalaureate Program, which is a program kind of similar to AP that some schools were doing, and they would have a religious leader come in and lead a prayer at the graduation ceremonies, and they said that was unconstitutional because that was the school endorsing a religion by praying at graduation time. All right. Santa Fe versus Doe is another good one. It's pretty recent, also I think made your book. Anytime the name Doe is associated with a court case, it's because the person doesn't want their name associated with this. This would be a student your age suing their school district. All right, and this had a law in Texas where schools would pray before football games, and both teams would get together. A student would lead a prayer over the loudspeaker. They'd hold hands and say a prayer before the game would start. And the court said that even though it was an extracurricular activity, it was still endorsing a religion. So the court has struck that one down as well. So if you're picking up a pattern here, you'll noticing striking down, striking down, striking down, that these cases are all striking down programs administered by schools pertaining to religion. So prayer and school essentially does not mix. Okay? And you're going to read an article about these at the start of class tomorrow. All right, I'm going to move this out of the way for you. Don't worry about these by name, but just take a look at them. Okay? They're both 2005. All right, and yes, the Perry one was in Texas, good old Rick Perry. And these both deal with the Ten Commandments. And if you'll notice, the one in Kentucky, all right, the court ruled that displaying the Ten Commandments violated the Establishment Clause, okay, because it endorsed a religion, that by putting the Ten Commandments on a courthouse, that's going too far. All right. Now, if you've ever been to Waukegan, there is actually a Ten Commandments display in front of the Waukegan courthouse as well. So let's see if we can figure out why that was accepted. In that same year, the court said that the granite tablet displaying the Ten Commandments on the Texas Capitol did not violate it. Okay, so a pretty tricky ruling here. Their argument in this case was it was a tribute to our history and where our laws came from in the Ten Commandments, not an endorsement of religion, because it displayed other things like the Constitution and Bill of Rights and things like that. Okay, so this had a more secular purpose. All right, first one was exclusively a religious purpose. And interestingly, both cases were 5-4 decisions. Justice Breyer, who Clinton appointed in the 1990s, was the majority decision in both of these. So he was the reason it flipped. So the other 8 justices were consistent. Breyer was the only one that flipped. All right, so that's the Establishment Clause. Moving ahead, Free Exercise Clause, also in the First Amendment. Okay, it says Congress cannot make a law establishing a religion or prohibit the free exercise. So it cannot get in your way of exercising your religion. All right, and only a few court cases here. We mentioned this in class today. All right, Reynolds versus U.S. Upheld a federal law that outlawed polygamy. All right, the Mormon argued that it was his religious freedom, and the court said that there was a greater societal interest besides your religion for them to outlaw that. And that case still stands today. Polygamy is not lawed in any states. Don't ask about the show on A&E or whatever, TLC, whatever it is. That's totally entertainment purposes. Okay, Wisconsin versus Yoder. All right, this was about Amish kids in Wisconsin that were required to go to school, or that wanted to do homeschooling because Amish didn't want their kids exposed to the modernity and modernism and things like that. And the court ruled in favor of the Amish. That said you did not have to send your kids, that was freely exercising your religion by not going to school in that instance. Okay, and then this is called Oregon versus Smith, or Employment Division of Oregon versus Smith. This dealt with the use of hallucinogenic drugs in religious ceremonies, peyote specifically. If I don't even know what that is, but it's something you shouldn't be doing. And what happened here is 2 of these workers were fired, and they tested positive when they were going to get their unemployment benefits for drugs. And the state of Utah said, you're not going to get any benefits because you were using drugs, and they said, well, this is part of our religion, and the court said that was okay, that you could deny unemployment benefits, that you did not have the right to use drugs in religious ceremonies. All right, so more times than not, the free exercise is going to strike down laws, strike down actions of people, that you're not going to use that to do things. With establishment, you're going to strike down the government action. Free exercise, you're going to strike down the individual action most of the time. There's also one about sacrificing animals in Hawaii, but we'll save some time on that one. All right, free speech cases. We also see that in the First Amendment. Okay, we cannot abridge the freedom of speech. All right, and that has been argued about since the Alien and Sedition Acts. All right, Shank versus U.S. Here's a little shout out to Mac. All right, good old Uncle Oliver Wendell Holmes. Okay, um, has did this case establishing what is called a clear and present danger test. All right, you'll need to know clear and present danger test for this one. Okay, and this one said that the government had arrested someone for resisting the draft and protesting peacefully, saying that it violated or it was being disobedient to military orders. And Oliver Wendell Holmes said that you could not do that speech. It was not protected because it created a clear and present danger to society and our war efforts. All right, so it kind of limited the right to freedom of speech. The analogy he made is that you cannot yell fire in a crowded movie theater because that is going to present a clear and present danger, and we don't allow people to do that. So why would we allow people to resist a draft and distribute leaflets and things like that? Okay, so Shank versus U.S. is the clear and present danger test. We got a lot of tests. We have the Miller test, which we'll hear about here in a second. Shout out to Taylor. And the Lemon test, clear and present danger test. There's others. Okay. Get law we covered in an earlier video. All right. This incorporated the First Amendment free speech clause for the first time. All right. Because of the 14th Amendment and your liberties being protected, all right, the court ruled that free speech is a fundamental freedom and states have to respect it because it's in the Bill of Rights. All right. Tinker Des Moines. Okay, this one is a student case, one of the few victories for students. All right, students wore black armbands to protest the Vietnam War, and the court said that that was symbolic speech, similar to Texas versus Johnson, and that it was protected. All right, and students have this right. Now you can't don't have a lot of free speech rights here at school. All right, look up Bethel versus Frazier if you want a good laugh. Bethel versus Frazier, but don't tell anybody I told you, even though it's on video. And in this case, they say as long as this does not disrupt the learning environment. So if your speech disrupts the learning environment, then the school can outlaw it. But in this case, wearing an armband silently does not disrupt the learning environment. All right? And here's one for you. All right? Anybody named Miller? All right? The Miller test, all right, deals with obscenity or indecency. Okay? And this set community standards for what is obscene and what is not obscene, because people would claim their freedom of expression to show certain things and put stuff on television, mailings, billboards, etc. All right, and the court said that they kind of deferred back to the states on this one, and they said that for something to be obscene, the theme has to appeal to indecent desires that apply to contemporary community standards. Now, what does that mean? The community kind of determines what's appropriate and what's not. If you live in a more rural, more laid-back community, you're probably going to have a little more strict standards. But if you're in an urban environment, big city, a little more looser with your standards. But it's kind of what the city determines is appropriate and not appropriate. Okay. The action could also show in clearly offensive way sexual behavior that's outlawed by state law. Okay, so child pornography, for example. And then if it lacks any serious literary, artistic, and political scientific value, it can be struck down. Okay, so it kind of clarified what obscenity is. It's actually kind of a funny story because when the judges were doing this, they actually all got together and went and watched movies to determine what obscenity was and what not. So picture 9 judges watching those movies. You get a kick out of that. All right. Last two, Texas versus Johnson, flag burning, symbolic speech. We talked about that. And then Morse versus Frederick, I just get a kick out of. This was a case in Alaska where a student during an Olympic torch rally held up a sign that said "Bong hits for Jesus," and the principal had ripped it down and suspended the kid. And the kid said that was his right to free speech. I'm not on school grounds. But the principal had given this kid's permission to leave school to go see the Olympic torch rally. So they said that he did not have that right to free speech, that principals have a right to promote good behavior and not support illegal drug use and Jesus taking a hit from a bong. So the court ruled against the kid and upheld that limitation of free speech. So most cases other than Tinker limit a student's right to expression in school. Bethel versus Frazier is one, Morse versus Frederick. There's also a yearbook one we're going to talk about here in a second. All right, the ones I would know and expect to see on the test: Texas Johnson, Tinker Des Moines, Gitlau, definitely that's a Super 6 case. Okay, meaning it's one of the 6 that's on every exam, and Shank has made it as well. Okay, Miller and Morse not so much. All right, our final slide here. Okay, deals with freedom of the press. All right, I'm sure we're going to anticipate seeing a newspaper here. All right, government cannot make a law respecting or limiting the free press. All right, that happens here. Okay. Near versus Minnesota rarely makes the test, but this basically said that free press is incorporated, that freedom of press is applied to the states as well. The state cannot limit your free press because it violates the due process clause. Near versus Minnesota. I've never seen it on an exam. All right. New York Times Sullivan often makes it. Okay. We should know our phrase is actual malice. If I'm going to sue you for libel, I have to prove actual malice, that you intended to harm me with your actions. Okay? New York Times versus U.S. All right? Remember, New York Times, New York Times. All right? This one dealt with prior restraint. Okay? The court reaffirmed its position on prior restraint that the government could not stop publication of the Pentagon Papers. But they also practiced judicial restraint because it only applied to this case. Prior restraint still applies in other cases. All right, and our final one here is Hazelwood versus Kuhlmeyer. This affects student newspapers, and the court said that you can censor a school newspaper if it is related to legitimate concerns. This did a story about, I think, divorce, and it singled out two different parents by name in the newspaper, and the community didn't want to get out that these parents were divorced. That's the 1980s for you. And the court said that the school had a right to prohibit censorship of that newspaper. And our principal also looks at our newspaper before it gets published, but we've never had any controversy with that. But schools don't have to do this, but if they do, it's protected. Protected by the Constitution, and the First Amendment does not give you as a student the right to free press in that regard. All right? And for those that listened all the way in, you will be rewarded because there will be a few questions asked at the start of class, but don't tell anybody because we don't want anybody to know that there'll be one of those little, what we call pop quizzes. All right? So you can't go 3 days without getting a grade in the grade book. So hopefully you're all paying attention. All right. Thanks for tuning in. We'll talk to you soon.